second part of the video, which is about motion orders. So
Okay.
let's say that, you had a motion and you lost. So are motion court orders kind of the same like treatment as what you said just now? I mean, can you go to jail or?
I don't want you to think of orders as what if they came from a motion or a trial or whatever, right?
Okay.
So I mean, if we had a big trial and there was a decision rendered out of that trial, it should be enforceable the same way as a summary judgment motion, right? It still just gets rid of the whole case.
Right.
So if a judge makes an order, a judge makes an order. So think of it like that. The thing to think about on a motion, though, is that the general rule in Ontario is that if you lose at court in a motion, let's say, you have to pay the winner's costs or a percentage of the winner's costs.
Right.
Usually a partial indemnity basis, it's called.
Right.
So not the full amount of cost, but a good chunk of it. If you don't pay that amount,
yes,
you're going to have problems moving forward in your case, right? So when you remember, a motion is just a piece of your case.
Right.
So it could be a motion for, better affidavit of documents. It could be a motion for striking a pleading or adding whatever.
Yeah.
But if you lose and you don't pay the cost award, then the other side can say, that's it for you. Your defense is we're going to strike your defense or strike your claim or whatever it is if you don't pay this cost within a certain amount of time. And there's a lot of cases that talk about this. Judges still have a lot of discretion if they want to enforce that or not. But for the most part, if you're not paying those cost awards, you're going to have trouble moving your case forward. Let's say there's a motion for a better affidavit of documents.
Right.
Okay? So the affidavit of documents is a part of the discovery process.
Right.
It's when you're putting in all your documents so that the other side can review them and get an idea of what you're relying on and what case they have to meet.
Right.
Okay.
Right.
Now, if you don't put a good enough affidavit of documents where that other side can't do all that stuff that they need to do,
right,
they can ask you for a better one.
Yeah.
They know you have documents that you're not producing. They can demand you produce. And if you don't, they can then bring a motion compelling you to. Okay. Now, let's say they win that motion.
Right.
And the judge says, Heather, you better do this and do it fast, right?
Mm-hmm.
And you owe them $2,000 for costs or something.
Yeah. Let's see.
So there's two separate things happening now. One, you've got to produce that better affidavit of documents.
Mm-hmm.
And the other is you got to pay me $2,000.
Right.
If you don't pay me $2,000,
right,
the case may be over for you.
Oh.
Right. I could then come to the judge and say, I don't care about her affidavit documents anymore. Don't let her proceed anymore in this case. And I want everything struck.
Mm-hmm.
Okay. If you don't produce the better affidavit of documents,
yeah,
maybe that could happen as well. Or maybe a judge would just say, well, you can't rely on the stuff you're not producing, or they might make adverse inferences towards your case. They could strike it as well, but those are just two separate issues, right? Not paying a cost order, whether it's an affidavit of documents motion, whether it's a default judgment motion, whether it's a refusals motion, whatever, the loser is going to have to pay some costs. And if they don't, they might not be able to continue in their case. And if you're a plaintiff, that's not good because you're trying to win your case.
Right.
And if you're a defendant, that's not good because the plaintiff can then just walk right through the case without you necessarily participating.
What does the word forthwith mean in practice? Because I know what it means theoretically. Who knows?
Who knows? I mean, I'm sure there's forthwith means right away.
Yeah, I know. Right. But what does that mean?
Right. But what does that mean is a good question. Usually when we argue with each other, us lawyers argue with each other.
Yeah.
Forthwith in my mind just means right away, within 30 days, that kind of thing. Right.
Yeah. Yeah.
But what it means practically is it means right away.
Yeah.
And it means that we're not doing anything else until this is over, until this is done.
Oh, interesting.
Right.
Right.
So it's you're doing this right now. That's your immediate obligation. It doesn't mean that you have to do it on your phone in the court, but it means that it's the next thing you're doing.
Well, the reason why I'm asking is because a lot of self-reps who are not in the profession, they don't know what the custom is, right? So when they hear the word forthwith, they're literally interpreting as right away. So, if I were a self-rep, I would say within a week, let's say within 2 weeks. So the reason why I'm asking is because sometimes it's hard for self-rep to figure out, okay, so how long should I wait for the other side to comply before? I don't want to look like I'm being a bully or anything, but how long should I wait? Now I know lawyers, probably you have some sort of probably custom.
I wish I could say we do. I mean, it's some lawyers. There's not enough of an agreement on this that I've seen.
Interesting.
But I mean, the way I look at it is, if I have an order that the other side has to do something forthwith, pay costs forthwith or whatever.
Yeah.
They don't get to wait to do it.
Yeah.
But if they have an issue, they just have to get started doing it right away, right? And they can't delay it.
Yeah.
But it doesn't mean that I want it by 5 p.m. that day. That's unrealistic.
Right, right.
But it's not a time for you to get to it later. You're going to do it right now.
Yeah.
And when I'm going to deal with that order later, I'm going to say it said forthwith, and use that against them if they're delaying, or if they want to do something else, and all this kind of stuff.
Okay. All right. So yeah, that's guidance. Okay. So let me just double.
Thompson v. Fleming, and this was a family case.
Mm-hmm.
And the judge says here, let me be clear, a cost order is not a choice. So they're talking about the same thing we were talking about before, a cost order and paying it, right? So the judge says, this is at paragraph 10. Let me be clear, a cost order is not a choice, and forthwith means now, not when it suits the party. It is it is foundational to our system of justice that court orders are obeyed. So, and I'm assuming if I read the rest of this case, the person who didn't pay is about to have something bad happen to them in this litigation that they're not going to want. Sure.
Okay, so wow, thanks, Dan, for sharing your insight with us today. And thanks everyone for watching. Don't forget to check out Dan's channel on Legal Tech. And also just a quick announcement here. Litigation Help now has a shop. We have guides on how to fill out motion court forms, and they are based on a very, very simple fact situation, and it comes with a completed example. And the link to the shop is in the description box below. And finally, if you're new to our channel, don't forget to hit the subscribe button so that you don't miss out on our future videos. And thanks, Dan, and thanks everyone. We'll see you next time. Bye.
Thanks, Heather. Bye-bye.